already did this, so we won't do the knock. All right, thank you, folks, for the temporary interruption. All right, Judge Bading.
I'm here and I can see you.
All right. Welcome. So we're here today on 23-2086 State versus Jordan. And as we mentioned earlier, Mr. Bender will represent Mr. Jordan and argue for him, and Mr. Rogers for the state. And whenever you folks are ready, we're ready for you, Mr. Bender.
Court. Judge Beatty, can you hear me?
Yep, I sure can.
Okay. Good afternoon. I represent Mr. Jordan on his appeal from the convictions for murder in the first degree and abuse of corpse. We raised several issues in this case that dealt with the jury selection, to whether or not a mistrial should have been granted, to the lack of sufficient evidence, and to the district court's ruling on the motion for new trial. We'll begin with the jury selection, and particularly whether or not the court should have struck juror number 14 in this case. We believe that if you review the transcript of the voir dire with juror number 14, it clearly shows that he had a predisposition that the defense was to prove the state wrong in the case.
In the transcript, it was pretty clear that the district court then asked a few questions with regard to, if I tell you that the defendant doesn't have to prove anything, that the state has the entire burden of proof, that the juror understood that.
The court asked only one sentence, which was, I believe verbatim, it was juror 14, if you specifically instructed by myself regarding the law and the defendant does not have to prove his innocence, that burden is entirely on the state. And the juror number 14 said, and would you be able to follow that instruction? And the juror number 14 says, yes, ma'am. But the most troubling is the repeated equivocal statements that just juror 14 made, that it was expecting the defense to prove the state wrong. It was expecting the defense to put on some evidence. And the most alarming statements that was made by juror 14 was right before the court interjecting, right before Mr. Jordan's counsel requested to strike this juror, was the juror was asked specifically, are you going to hold the defense to some sort of standard of having to prove something? The juror says, I think so, my opinion. Then the juror goes, then when the defense attorney says, kind of was inquiring a little bit more, is there a way I can change your mind with respect to that? And juror 14 says, we'll find out. And that kind of alarmed the defense counsel and asked a follow-up question, well, I don't want to have to wait to find out. And then this is the most alarming statements that juror 14 made. It says, that's my belief right now. That's the way I've always been. So one line by the court to try to rehabilitate this juror, whether or not you can follow the instructions of the case, does not overcome what this juror's firm belief is, the predisposition, which is that it's expecting the defense to prove the state wrong. So it's clearly this juror should have been struck in this case. That's really the only issue for this court. The state has conceded that there's prejudice. If you find that the court was, if the court was wrong in not striking juror number 14, they followed the Jonas. They used the peremptory strike on juror number 14. They identified another juror number 32. They provided a reason why they would have struck juror number 32. So we feel that on this issue, the one rehabilitation statement by the court does not overcome the firm predisposition that this juror had, which is that they're expecting that the defense to disprove the state. Now, that's not the only error that we're alleging that occurred during the jury selection. We do feel that the court also erred for not allowing the jury questionnaire. In this state, prior to trial, the defense counsel asked for a proposed jury questionnaire. It had a very limited number of questions that dealt with pretrial publicity, but most important, also implicit bias due to the race of my client. The court denied without a hearing. It said that all these issues that the defense was bringing forward in the proposed questionnaire could be feathered out during the jury selection process. We're arguing that this was abuse of discretion, given the sensitive nature, especially implicit bias, having jurors in open court to be able to be truthful and honest, or even in a closed setting, even in a one-on-one questioning, to be able to get that out is not the same as having a quiet setting and on a paper to write about what they firmly believe. And we feel that that is very important, especially when it's very difficult. I know the court in this case, and even I think in the defense motion with respect to the proposed jury questionnaire, talked about how at that moment they were not able to make a plain Lily argument with respect to the jury pool, so they were asking for this next step, which is the proposed questionnaire.
He says that that's an abuse of discretion, do we?
No, we don't. We have the line of cases that talked about that courts should really be focused on in this implicit bias. We also have the cases which says that there's not one true method that the courts can employ in order to inquire about that. I mean, we acknowledge that that's where the state of the case is where we're at here. But, you know, the court's reasoning to dismiss this was it will prolong the jury process. It was going to make it more complicated. If you look at the proposed questionnaire, there's nothing complicated with respect to those questions. They were pretty straightforward questions. It was not going to prolong, you know, the jury process any more longer than if you asked the questions. But the one good thing about having a private jury questionnaire is that you'll get more truthful responses with respect to that. So we think there was abuse of discretion with respect to the court denying the questionnaire.
Counsel,
Yes.
if we reject your structural error argument on that claim, can you explain how your client was prejudiced by the court's denial of his request for the questionnaire?
Because we're arguing that the jury process of the jury selection was tainted because they're not allowed to have the jury questionnaire to be able to have to be able to try to pick a jury that did not have either the pretrial publicity or the implicit bias. And because of the jury selection it's not what actually occurred, it's actually the process how we got there. By them denying this, it goes to the structure of the whole jury trial. So therefore, at that moment, that's where the structure error comes into play.
Okay, thank you.
Counsel, can I have you real quick, because you're getting close to not too much time left, to pivot and talk about the mistrial motion? The mistrial motion.
On the second day of trial, the state came forward. Actually, it occurred at the end of the first day in the evening. The state alerted the defense that they had finally got the phone dump from my client's phone, and that they gave him some text messages. But that next morning, Mr. Jordan's attorney stood up, asked for a mistrial. The state had this for about 4 or 5 days prior, and did not give over the information. And even at the time of the mistrial motion was made, it was they still didn't have the information. The alternative argument was that they would be allowed at least 4-day continuance to the following Monday, which is almost equal to what the state already had in their possession with respect to the evidence. The court denied that right away. The court's biggest theme, if you look at even going back to the jury selection, it's like, we can't prolong this trial. We have witnesses here. We have to do things in haste because we can't prolong it. He only gave them to after lunch initially. When he denied the mistrial and then he denied the 4-day continuance, Mr. Jordan's attorney's like, hey, I need some time here. I got 32 gigabytes of data and I can't go through this stuff. The person who extracted it is out of state at a funeral. I can't even talk to them. And the court goes, well, we need to keep things moving along here. Now, I understand on certain trials, keeping things moving along makes sense, but this is a Class A felony where someone's life at liberty is at stake because, I mean, the ultimate punishment is life without parole.
Standard that he had more time and he should be prepared for trial on Friday morning, right? And when he got there Friday morning, was there any record made, like I still need a continuance or?
Because The compromise that was worked into play between the trial court and defense counsel was when the mistrial was not granted, the 4-day continuance was not granted, was can at least have until tomorrow morning, because the court wanted to keep going. The court wanted to take witnesses that afternoon. And they're like, well, we really need some time to look at this because there might be some things here that we need. But the court's like, well, we got, their biggest thing was, let's keep moving along. So that's when this, there was no additional record made because they were going right into the next testimony that the court wanted to do. I have only 7 seconds left here, so I will reserve the rest of my time for rebuttal. Thank you.
Thank you very much. Mr. Rogers?
Please, the court, counsel. I have three issues that I wanted to focus on. There was the disclosure of the phone, and it's the defendant's phone, and it was the clarification, not the rehabilitation of the prospective juror, and the overwhelming evidence that clears up any errors that would happen, save for the prospective juror. I can start with the prospective juror. The lead up to the challenge was sort of confusing. The way we read it is the defense counsel was asking jurors their opinion of how the trial would go. How do you think trials happen? And this juror said, well, my opinion is that the defense should put on some evidence. If the state puts on evidence, the defense should put on evidence. And this can be a good voir dire tactic. Lots of lawyers will say, well, the rule really is this, and will you be able to follow the rule, even though your opinion is that? And I think that got lost in the back and forth between this juror, because I think this juror had strong opinions, and that comes through. And so the district court needed to clarify, and is allowed to clarify under Rule 216.6, what the challenge is for. And I think that the question that my colleague put out is exactly what a district judge should ask when clarifying in this situation. Here's the rule, are you going to be able to follow it? And the prospective juror said yes. And defense counsel...
Yeah, I'm sorry to interrupt. Where's the line between clarification and rehabilitation? So if this wasn't rehabilitation, what would be?
Well, I think Jonas and Neuendorf give good examples of what rehabilitation would be. It's where the district court says, well, this is your view, this is your opinion. Can you set this aside and follow the rule anyway? And a lot of the time, there's more back and forth than that. The juror will say, well, I might have a hard time. That was in Jonas. The juror waffled, and the district court really worked, which was okay before Jonas came out, and worked to try to see if the juror could follow the instructions. And that's exactly what we're looking for in prospective jurors, is jurors who will follow the instructions of the court. And we have a presumption that jurors follow the instructions that are given. And this juror, to the defense's follow-up, said, yeah, the judge told me what I'm supposed to do. I'm going to do that. And I think that's what we should expect. 216 sub 5 also requires, when there's a challenge for cause made, that the facts supporting that challenge for cause be set forth, and defense counsel didn't do that here. So I think clarification is doubly important in that situation. So we ask that you affirm on that issue. Turning to the disclosure of the defendant's phone, there's no surprises here on what's on the phone. It's the defendant had the phone, and he really had access to the phone the entire time that the state had it. There was a warrant that was served on him to try to get facial recognition to open the phone, and he frustrated that by looking down, which I didn't know that you could do. So if he wanted what was on the phone, he could have had it at any time. The defense cites constitutional provisions, Brady and the compulsory process and the right to counsel, and principles from all of those, but none of the rules apply here. None of the rules will apply to these facts. What the district court was dealing with is Rule 2.14, is the discovery requirements for the state. And the state did have the obligation to turn over the phone when it had it. The district court said, well, you should have done that sooner, found that there was a violation of 214, and then remedied it. And that remedy is pursuant to 214 sub 4, and that provision gives the district courts complete discretion, basically, on what to do for a discovery violation. It says the district judge can continue, the district judge can order inspection, the district judge can rule that the evidence is inadmissible at trial, or any other order that the judge thinks is just under the circumstances. So this is the district judge's widest discretion. The district judge kind of slow played how the phone came out, said, all right, I'm not going to grant a mistrial at this moment. Let's see how it goes. The defense came back twice before lunch and said, let the court know how it was going, and said, I'm not going to be ready for witnesses at 1 o'clock. Was the final meeting, and said, but if you give me until tomorrow morning, I'm good, I'm fast, I'm efficient, I can get it done. And the district court gave the defendant what defense counsel asked for. And I think that is a great exercise of discretion. We can't say that giving the defendant what defendant asks for is an abuse of discretion, I don't think.
Was there ever any record about prejudice in the use of any of the material from the phone dump?
There wasn't. My understanding is that defendant wanted those messages as much as the state did. It went in with defense's theory of the case that Jordan and Esparza were going back and forth with who took the drugs. Let's go find these guys. So I think that wasn't prejudice. It wasn't raised as prejudice. It's not raised as prejudice. We still don't have any allegations of what would have changed if the defendant would have had more time. So we don't think it was an abuse of discretion, and there was no harm from it. On the juror questionnaire, there's cases that I cited said we trust rigorous voir dire to expose any prejudices. And I think that's what the district judge was expecting, and went through all of the things that would be required for the court to take this questionnaire, to take its 5 broad questions asking for essay answers, get those copied, given to counsel, evaluated, figured out. The district judge knew that all of that could be done in the courtroom in voir dire. And I think that was an exercise of discretion. Voir dire and jury selection is in the district court's discretion. And there's no harm, and that will lead me to what we see as the overwhelming evidence of guilt in this case. That satisfies the sufficiency of the evidence, satisfies the harm and all but the juror issues. It's not many cases where the defendant tells the victim, I need the stuff back that you took from me, or blood is going to spill. And then the victim ends up dead. I think just on those facts alone, with the inferences that the state gets to the jury's verdict, that could be sufficient evidence. But we have more and more and more. The note is in the car trying to deceive the investigation on what happened to John Esparza. It's clearly written by defendant's girlfriend, mother of his children. There's evidence on the match of the paper torn out and the handwriting, and there's a first draft that says "Be back soon," and did the second draft "Be back soon" that went in the car. They're trying to get away with it, and the police come to Jordan's door first thing, because that's where John went the night that he disappeared. So they went to his house and asked him, you know, do you know where John is? And he says, oh, I knew John a long time ago. I've seen him a couple of times. And, you know, the evidence comes out that he's been messaging him back and forth all that week. He tells the police he was in Texas. Turns out he had a document notarized in the neighboring county that on the day that John disappeared, and that he had the bonfire in the backyard. And all of that leads up. We don't even get to the axe in Jordan's kitchen with John's DNA on it and his bones in his burn barrel in the backyard, his wallet, his keys, his necklace. The evidence is overwhelming that Jordan committed first-degree murder and abused the corpse of John Esparza. We'd ask the court to affirm the convictions.
Yes. Your Honors, I think it's just a matter of difference of opinion on whether this is a clarification or rehabilitation. I think a clarification would have been if the district court asked juror number 14, what do you mean by that this has always been your belief, that the defense should prove the state wrong? That's a clarification. A rehabilitation is what happened here, where the court says, well, you're going to follow. If I instruct you based on the instructions, are you going to be able to follow those? He's trying to rehabilitate so that the only response that most jurors are going to give is yes. A juror's not going to, in a courtroom, if the court says you're going to follow my rules, they're not going to say no. They're only going to say one response, which is yes. So we have to go back and look at what he actually said here. Now, yes, maybe, however this came out, however this was elicited from juror number 14, juror number 14 was steadfast throughout all his responses, that he was expecting the defense to disprove the state. And he said this has always been his opinion. Now, we feel that alone is a sufficient reason to strike this juror. I do want to take one moment here to talk about another issue that we raised with respect to the motion for new trial and the brief order that was issued by the court making that ruling. The court only stated, quote, I believe that the greater amount of the credible evidence does in fact support the jury's verdict on both counts, end quote, with respect to his ruling. We feel if this is an abuse of discretion with respect to that issue, it does not provide meaningful appellate review. This court only has one obligation, which is not to decide the underlying question whether or not there's credible evidence or not, is whether or not the court abuses discretion. And in order to find abuse of discretion, we have to have some reasons on how the court arrived at that decision. Therefore, this brief statement by the court does not allow this court in its appellate capacity to review the abuse of discretion. That should be remanded with respect to that issue for the court to articulate its reasons for the denial of the motion for the new trial.
Quick, just speak to the argument of counsel that as to what would have changed if you had received a 4-day continuance versus the 1-day continuance.
We don't know because the record's silent. All we do know is that there's 32 gigabyte of data that was provided to the defense counsel. I acknowledge the defense counsel stated that she's going to try her best to go through that. But we know that there was several thousand messages, there were 7,000 emails, I think several hundred text messages, I think there was several hundred photos that was done. So the record is silent, and I think the reason why is trial is beginning the next day with testimony. And there was already witnesses lined up. So I think whatever was given, they tried to use their best, but they had to go into the trial because the court says the trial starts next morning. That was the best that we could get. Yeah.
That it's his phone anyway, so he would have had access to it.
The state seized the phone. It was in the state's possession. The state tried to get into the phone. The defense counsel for several months asked, have you gotten into the phone? The state kept saying no. Even when the state did get into the phone the Friday before the trial began, they did not disclose any of that until the day of the night of the jury selection after it concluded. So in this case here, the state was on this evidence for several days. The defense counsel comes in, first thing out of their mouth was a mistrial because they were ambushed with this phone dump that was happening on the second day of trial. Then they made the alternative to give us the same amount of time in equity that the state had with the information. The court said, no, we're starting back after lunch. So here, this defense counsel is trying to do their best here, say, hey, we can't talk to people, we can't, we're trying to go through stuff. I haven't even showed my co-counsel the information. So the only compromise was, and the reason why there was a compromise was, the court was going either after lunch or they went the next morning. So they tried to buy as much time they could to go through this stuff. But we do not know in the record what could have been or not. And I don't think that, to be honest with you, I don't think the trial attorneys probably know everything that was in there because they didn't have enough time to do it. So we ask that you reverse Jordan's conviction and remand us back for the relief that we requested in our brief. Thank you.
Thank you, counsel, for the excellent briefing and arguments today, and we will consider State versus Jordan submitted, and my colleagues and I will get out a ruling as soon as we can. Thank you. And thanks for putting up with our technical problem.